Good morning, everyone, and welcome to the 49th edition of Anekdhara. Thank you for joining us today for our webinar titled Data Governance in India, Civil Liberties and Accountability. Today, we have not two, but three incredible speakers with us to share their insights, questions, and concerns surrounding the Digital Personal Data Protection Act and its corresponding rules, known colloquially as the DPDP Act and DPDP rules, and its broader place in the larger conversation about privacy, surveillance, and data protection within India. The notification of the Act and the rules were notified last year in late 2025. It follows over a decade of public policy developments and discourse in India, which included several expert committees, such as the Expert Group on Privacy that was constituted by the Planning Commission, which included Dr. Ramanathan, as well as the Committee of Experts on a Data Protection Framework for India, constituted by the Ministry of Electronics and Information Technology, that was chaired by Justice Krishna. The late 2010s to the early 2020s saw multiple iterations of the Data Protection Bill, which at different points were opened up to public consults and referred to parliamentary standing committees as well. The approach and substance of this framework, therefore, has seen immense discussion, including considerable apprehensions around the nature of the proposed data governance. The framework represents a major shift to a much more systematically regulated landscape meant to protect the fundamental right to privacy, as recognized by the Supreme Court of India. However, this evolution faces intense scrutiny with respect to the tension between state accountability and civil liberties. While the framework introduces robust obligations for data fiduciaries, that are entities that collect and use personal data, and creates heavy penalties for breaches, it also creates several broad governmental exemptions, amends the Right to Information Act, recognizes circumstances that warrant mandatory data sharing from data fiduciaries to the government. And therefore, many experts argue that the phrasing of these provisions are vague and can therefore open the door to greater governmental surveillance. Moreover, it is argued that in its present form, many of these provisions may not pass the tests of reasonableness and proportionality that were laid down by the Supreme Court of India in their landmark right to privacy judgment. The fault lines in this framework lie in the interplay between its key actors, which are the individual citizen, the state, and the entities that collect and process individuals' personal data. The broad questions, therefore, that we need to answer and look at are who uses and benefits from whose data, who is protected from whom, and who is accountable to whom. And hopefully, through the course of the discussion, our viewers will be closer to answering these questions. So without further ado, I will introduce our first speaker for today, Mr. Apar Gupta. Mr. Gupta is the lead counsel at the law offices of Apar Gupta in New Delhi and serves as the founding director of the Internet Freedom Foundation. He holds a master's degree in law from Columbia Law School. And as a lawyer, he's worked on commercial disputes at Karanjawala and Company as an associate, and then as a partner at Advani and Company. From 2013, he has worked extensively at the intersection of technology and civil rights through strategic litigation in various cases, such as the Puttaswamy case, the Shreya Singhal case, and more. In addition to the Internet Freedom Foundation, Mr. Gupta's public service work includes being a member of a subcommittee for privacy of judicial data constituted by the Supreme Court of India. And he's also on a panel of legal experts of the Editors Guild of India. His writing has been published in peer-reviewed journals and papers, and in papers of record, such as the Indian Express and the Hindu. And he has also conducted courses at the National Law School in Bangalore and National Law University, Delhi. It's a pleasure to have you with us today, Mr. Gupta. The floor is yours.
Thank you so much, Ronak. And 2 days before, when the National Economic Survey was released, at least four of its chapters conspicuously mentioned the state's role in promotion of digital and technologies in core areas of what the state views as priorities for national development, which go beyond economic priorities to the social lives of every Indian. And at its very foundation is how personal data from us is gathered, is utilized, and is harnessed not only by the public sector, but also by the private sector. Here, I'm grateful for the opportunity to sit alongside Justice B.N. Shri Krishna and Usha Ramanathan, from whose work I've learned and engaged. Usha Ramanathan is a person from whom I've had the opportunity of collaborating on the civil society response to biometric identification, which has been imposed in a coercive manner on every Indian. And through Justice B. N. Shri Krishna, I've had the opportunity on engagement on data protection and how it's evolved into a framework which today has legalized an unequal power relationship between citizens and the state as well as the private sector, which is popularly referred to as big tech. In my remarks, I will set out a basic political economy background which lays into the process which led to the development and the legislation of the law as it is today. In addition to that, I will highlight five broad themes under which the law needs to be examined and the criticism which is emerging from civil society which may benefit subsequent remarks. Parts of my comments are based on an analysis which has been made by my colleagues at the Internet Freedom Foundation, which is specifically focused towards civil society. With civil society, I mean journalists, people who are RTI activists, people who are community organizers, people who work on the grassroots and will be impacted by the law. I will drop a link to that brief, which looks both at the act and the rules, and may provide greater specificity and grounding within the reading of the law to my comments, which may seem more opinionated. I hope more enjoyable. So let us start. Where does this law come from and how is it landed in our laps? So 11 years ago, a lot of us were dissatisfied with the UPA's second term, and this is according to the post-poll surveys by Lokniti CSDS and CASI UPenn. These were grievances which may no longer seem relevant, but along the way in the last 2 years of its government, which was following the 26/11 terror attacks, which led to the creation of NatGrid, for instance, or the securitization of the Indian state in many ways in its modern conception as we experience it today, or the anti-corruption Anna movement, which also led to a weakening of executive power at that time, however, ushered in a new government. There seemed to be a phrase which was used quite often by the newspapers, which was policy paralysis, right? And around that very time, what was happening was that there was a conversation around digital data protection, which was emerging on the basis of a biometric identification program, which was rolling out with an aggressive speed, which was using the official terminology of seeding and putting targets to how much percentage of a population is seeded with Aadhaar. However, finally, what has happened is that Digital Data Protection Act, which is called DPDPA in tech policy circles and by lawyers, was passed by Lok Sabha on August 7th, 2023, Rajya Sabha on August 9th, 2023, and received assent from the President of India on August 11th, 2023. This is the law which came to be. So, between the fall of the UPA and the law which was made, what were the processes and what did we learn from it? And did we apply those learnings to this law? So, when we look at one of the first committees which was set up or looked at the creation of uh, any kind of data protection, we should first look not at the Justice AP Shah committee, which was constituted by the Planning Commission, but the legislative process around the National Identification Authority of India Bill 2010 and the Standing Committee report for it. Because in its very statement there, in its very report, there is a recommendation for the creation of a national data protection law. And this recommendation leads to the creation of the Justice AP Shah Committee, which is notified and constituted and publishes a report on October 16th, 2012, and does a largely a comparative analysis of policy principles of different policy frameworks like I think so, APEC, and looks at then the statutory framework as it exists in India, which includes the absence of any law for surveillance regulation. It makes recommendations how a law needs to be made, which is generalized as well as specific amendments need to be made. And in this vacuum, around that time, Aadhaar is challenged on November 10th, 2012, because it is rolling out while these processes are happening. And yet again, There is no legislation which takes place for a long period of time till the next government comes because of this policy paralysis. Now, promising greater decisiveness when the NDA comes in and is sworn in on May 20th, 2014, we may remember what were the pre-poll promises of this political formation. It states that the Prime Minister has called Aadhaar a security threat, but then in government has a change of heart and or mind. And on the contrary, there's also been a institutional gridlock in some ways in the Supreme Court, in which there doesn't seem to be any law which is coming in for its recognition. So the status quo stands. It keeps proceeding on the basis of an executive notification. There is no law to regulate Aadhaar. There is no law to regulate data protection. And what is existing in terms of a case which is pending in the Supreme Court concerning the right to privacy. So it's a larger question of the fundamental right to privacy in which data protection becomes a component. And here, the date, August 11th, 2015, is really important because it is on that day the Attorney General disputes the constitutional basis of the fundamental right to privacy, which fuels the continuing expansion of Aadhaar. Because when a reference is made by the Supreme Court saying that, yes, perhaps in case law, which in my view may not have been warranted, perhaps in our view, we do not know how textually the fundamental right to privacy emerges within the Indian constitution, under which article of part 3 of the constitution there is a limited stay which is put on Aadhaar to specific purposes, but even that order largely is not respected. And then, of course, we have the Aadhaar Act, which comes in 2016. And this legalizes the widespread private sector use, not only its use in plugging leakages, and it also legitimizes the biometric coercive collection of identification as a basis of digital identification for the welfare state. And it is introduced as a money bill, and it is thereby denies any voting rights to the Rajya Sabha. And the five amendments which are also made to it and such in the Rajya Sabha are thereby ignored, because in the Rajya Sabha at that time the opposition did have the numbers. So you may also look at writing around that same time whether Aadhaar deserves to be a money bill. And this is at the core of the legality of the process, how we have made these laws. M.R. Madhavan of PRS Legislative, writing at that time, states it did not seem to fit the criteria of a money bill under the Indian Constitution. And on August 24, 2017, the Supreme Court affirms the fundamental right to privacy and states that it links to every right under Part 3 of the Indian Constitution. In fact, the opinion by Justice Chandrachud states that there's been a statement by the government, there'll be a data protection law which will be made, and it should be made in line of the right to privacy within this judgment. So the data protection law needs to be on the basis of the, at least as per one opinion, needs to be on the basis of the Puttaswamy judgment. And it articulates the fundamental right to privacy, which we can get into greater detail at a later point in time. Now, during this process, right, when the fundamental right to privacy was being announced. Prior to that, there was a notification of a so there was a notification of a committee, and there was stated in which Justice Sri Krishna was the chairperson. And around that time, there were also arguments which were being made that Aadhaar is conceptually unsound, which also gave rise to a lot of fear, suspicion, and also the composition of the committee did not take into account a lot of membership from civil society, as we see. So this is important. This is marked in even I think, a letter by Justice A.P. Shah to the committee. And what it shows also is that if we had followed a pre-legislative consultation policy, we could have possibly come to a bigger question mark on ultimate recommendations, such as what will be the effect on the Right to Information Act? What would be the exemption for public authorities? However, I may note that there was some public participation on that. There were roundtables which were held in different cities. There was a approach paper and there was a committee report. And there has been a rapid deterioration in these standards, and the pre-legislative consultation policy, which was not followed then, is not followed now. And there has been a further deterioration because today the nodal central ministry, which is the Ministry of Electronics and Information Technology, in fact, calls for stakeholder consultations rather than public consultations, which leads to corporate capture of public policy processes in India. Now, you may also look at the data protection bill, which emerges from this committee, which is the draft, which is a base draft, which is used, introduced in Parliament, referred to a JPC. And the JPC also sidesteps a standing committee on IT where it should be ordinarily gone. This is again fairly captured in a lot of the writing around that time. The JPC makes about 97 amendments in December 2021, and the law, as it had been tabled, is taken back. The government says and gives the assurance on the floor of the House that we'll come out with a new bill which takes into account the recommendations of the committee. And this promise is broken when the Digital Data Protection Bill 2022 is made available for public consultation in November 2022. It's a completely new draft. It deviates from the Justice B. N. Shri Krishna draft, the Puttaswamy judgment, the recommendation of the JPC. It has new language, it has new chapters, the provisions are all reworded dramatically. So, in many ways, it's a fresh draft, and it is stated that this compresses the law, makes it much more simple, and much more practical in its implementation. This is called the Digital Personal Data Protection Act, or the Digital Data Protection Bill at that time, DPDPA. And one core part of how this simplicity is achieved is by completely reducing the legality which is present in statutes by making the phrasing of each sentence in that statute vague and dependent on a subsequent notification which will be made by the executive authority. Thereby, the statute does not have the necessary ingredients which are necessary, which are deliberated by Parliament itself. And I've told you how it comes to be introduced in past in a fairly short time. And this is also during opposition boycott of Parliament due to the absence of the government to provide assurances and to make clear statements regarding the violence and unrest in the state of Manipur, which had been continuing for some weeks. Now, what this process and what this entire thing shows is that there are two things which I want you to take away from it. The first is that the basis of the data protection law emerges from the Aadhaar biometric program. And it is linked to fundamental right to privacy, particularly much more clearly the Puttaswamy judgment. And secondly, the policy formation processes which go through policy paralysis lead to a very rapid and aggressive acceleration, which completely disregards the processes, the time, the deliberation which has been caused by democratic processes for the making of a data protection law. And the data protection law is passed, I think so, without adequate thought. And thereby, it reflects in five core things which I hope are touched upon in future. First, the absence of surveillance and surveillance regulation, which is also a part of data protection in a way if you don't have surveillance reform. India has never had surveillance reform. And there was a conscious decision from the Sri Krishna Committee report, which did acknowledge surveillance does need to be reformed, but placed it in a separate bucket. According to me, surveillance in which there's not only an intelligence interest anymore, but even revenue departments are gathering, bundling, and sharing our data databases of individual citizens in which we don't have the ability of consent, right? Is a real problem. NatGrid has been expanded beyond intelligence gathering and sharing for prevention of terrorism now to uses for regular cases of theft to the state police, right? And there's no regulation for NatGrid. There's no underlying law, thereby no underlying limit to how it can be used. Now, the Data Protection Act does not take into account or does not provide that full ambit of protection to your right to privacy in a digital era, because it is only applying to consensual sharing of information in which there is notice, there is consent, and there is a limitation on the basis of that notice to the purpose that data can be used. Even then, this law is problematic. It's made an exemption for AI companies. It's made an amendment to the RTI Act number 2, which is dramatically changed Section 81J. It has also deleted a proviso which placed citizens on the same standing as legislators, in which legislators could ask questions to government, and the RTI Act had provided that if the answer can be provided in Parliament, and RTI on that same basis can also be made. That's deleted. There's a lack of a journalistic exemption, which existed in all previous drafts of the DPDP bills. And this lack of journalistic exemption is also a deviation from international norms, even the stringent European Union's GDPR. There's the power for the government to call for information, which is not grounded to an ongoing criminal investigation, lacks procedural safeguards, deviates from any kind of constitutional framework, and there is a lack of independence in the body which will adjudicate the law. There's no regulatory body in this law. This law is notified. There'll be notifications and rules made by the government ministry directly. It will be directly administering the law. But for breaches, data breaches under this law, there'll be a data protection board, which will adjudicate the complaints of data breaches and levy penalties. And this lacks complete independence. There is a search cum selection committee appointed by the government. Its recommendations and nominations are then vetted by the central government, and there is clear language in the law. The central government can completely disregard these recommendations in the staffing of the data protection board and the recommendations of the search cum selection committee. And with this, I can get into more detail on each one of these points, where the Data Protection Act and its rules stand in further conversation. Thank you so much.
Thank you so much, Mr. Gupta, for that excellent presentation. I particularly, amongst various things, I particularly took note of how you examined, and I've read in your past readings about how you've examined the changes in the consultative process. And I would love to explore that further and ask about your experiences and everyone on the panel's experiences in this consultative process and how that's changed from perhaps less substantive to somewhat more performative. Moving on, we have Dr. Ramanathan speaking as our second speaker. Dr. Usha Ramanathan works on the jurisprudence of law, poverty, and rights. She researches and writes and speaks on issues that include the nature of law, the Bhopal gas disaster, mass displacement, eminent domain, manual scavenging, civil liberties, including the death penalty, beggary, criminal law, custodial institutions, and the environment. She's been tracking and engaging with the Indian National ID project and has written and debated it extensively. She has also been writing and debating issues of technology and the human conditions of freedom and liberty over the years. She's currently engaged in a series of discussions with philosophers of science, historians, and technology professionals thinking about a philosophy for technology. We're very grateful to have you with us today, Dr. Ramanathan. I'll let you commence your presentation.
Okay. No prelude, no preliminaries. I'll just jump into it because I think we have a lot to hear. Apar, I'll just take off from where you kind of left off and introduce some other concepts. I think one of the things that's helpful in the way you presented this is that you've told us what the Indian context is. And I think we need to globalize our understanding when it comes to technology, because technology is not confined by geography. Interestingly, most of the big tech people are confined in their geography in terms of where they are locating themselves, but they don't confine their work to the geography in which they live. So it's like every one of these, big tech companies are every day in our lives. And I think it is important to start understanding what that means, because these projects, a digital data protection law also has to account for this. That it's not just, have you looked into my notebook and have I looked at your bank passbook? It's far, far more than that. And when the privacy debate was on, one of the things that we were told was that, oh, Indians don't care about their privacy. And it was interesting that when we looked at it, many Indian languages did not have a word that, that said privacy. And that's the time that we realized that so long as we didn't feel a threat to privacy, we didn't feel the need to assert our interest in privacy. It's only when the state came up and said, people of this country don't have a right to privacy. Then we started creating the language which would help us address that, because we hadn't needed to do it before. And I think, that's really important, because it's not like the Indian state had forever felt that, these people, they are just our subjects and we've got to do what we want with them. Conceptually, I just want to bring in what Kannabiran had, KG Kannabiran, who's one of our best constitutional thinkers, in the past 70, 80 years. How he told us to think about the idea of who we are in relation to the state. And he said, the journey that you make from being a slave to becoming a subject, and then from being a subject to becoming a citizen, these are huge and arduous journeys. When we talk about the national movement, we don't often recognize that this is the battle that we were, fighting, saying that we are our own people. If we are not careful with this, and if we think, okay, I've acquired citizenship, I don't need to think about anything more. I think by now we know, in the circumstances in which we live, that there is no given in it. We have to keep on fighting for the idea of citizenship. The idea of citizenship is not about just a political category. It is about what it allows a person to experience in terms of liberty and freedom. And that technology is challenging every part of the way. Data, of course, we often wondered, because those of us grew up in my time, you would say, whether it was Asimov or a few of the other sci-fi people that we read, that they had this imagination of AI a long time ago. Why is it becoming such a big thing now? And it's pretty easy to see it, because the whole point is about digitizing everything so that it's easily accessible in what is called a non-rivalrous manner, which is that you can use the same data at the same time that I can use that data, and it can disappear and we won't know it, and we can make it appear and reappear. Unlike, material things, for instance, like land. When the battles are around land, you're seeing it. It's only one person who can use it, or, a set of people. But it is a visible, it's visible, and it's visible matter, and you know what you're doing when you're, and what you're doing with it. Whereas that's not true about data. And somewhere in the early 2000s, very early in the 2000s, the idea of e-governance was introduced. And it's not just in India, it was introduced in many parts of the world. India, interestingly, was the one place where they found it very easy. There was a recent interview with Bill Gates, where in the process of a long interview, he says, he's asked a question about India, for instance. And he says, if you come to India, it's a lot of chaos. When you come into it, you feel that, but actually it's a place where many things happen. And he says that the Gates Foundation, the second biggest office after their US office, is actually in India. And he says, we experiment our ideas in India, and if it works, we take it to other parts of the world. So I think as people who are in this country and who are studying this law and looking at all of this, we need to understand why people think it's so easy to experiment on us, using our data, using information about us, and then creating various kinds of things which then they can take to different parts of the world. It's a very important statement, very important admission that he's made, and I don't think we should, lightly go past it. It's a very serious statement that's being made. We also know that the World Bank had been telling, the companies like L1 Identity Solutions that, many of these are like biometric technologies. They were created, and many continue to be created in the defense sector. And then it's about bringing them into civilian spaces. So from before 2010, L1 Identity Solutions had been told, now just take this, biometric technology to different, essentially to the developing world, and apply it where the easiest place where you can apply it is where the state is providing something for a set of people. They will be least able to resist, and the state can demand what it wants, and you can experiment there. So take it to those places. So the idea of biometric technology is coming among especially persons who are reliant on the state for support. This is not a new phenomenon. So, and we see that, the World Bank was pushing it. Now, immediately after that, you see L1 Identity Solutions was one of the companies that provided biometrics in this country. So we do need to understand that there's a geopolitics to it. And to see, when we test the DPDP Act, we have to test it to see whether it accounts for any of these things at all or not. It's not just about collecting data, processing data. In any law, we look to see what it says. We also look to see what it does not say. And I think Apar referred to some of that which it does not say. And I'm just adding to that of what it simply does not say. Apar mentioned NatGrid. I think it's really important to say this because NatGrid was after the 26/11 Bombay attack. And it came through a FICCI report where they held the meeting. This happened in 26/11. In December, they had the FICCI meeting and they were suggesting that you need to have all these various things, which included NatGrid. And in the first meeting in the AP Shah committee, in the first set of meetings, the NatGrid chief was there and he said, listen, we are just going to be a pipeline. We are not going to do anything. We won't even look at this information. It's private from us. But there are some agencies which the state will say needs it for national security purposes. And they can collect it, so maybe about 10, 11 agencies, and there'll be about 20, 22 databases. They'll collect data from that, and that's it. It's about travel, money, things like that. And we find today, again, like, Apar has already mentioned, but I think we need to stress the point that the Home Minister has actually asked, he is imploring, if he knows, if you can call it imploring, I don't think he would approve of being told that he is imploring anyone, telling all policemen across the country to please use NatGrid in their investigation and in whatever it is that they want to do. So the idea of linking up people through their identities in different places, we are not slaves. We are just products of some kind, but we are certainly not even subjects at this point because we are having things being done with our data. If you look at the DPDP Act, they say if there is a financial transgression anywhere, then all rules fly out. So if somebody is charged with a financial, it's not like they've been convicted even. And you just have to charge a person with it. And the DPDP Act allows all manner of data to be aggregated so that you can then track them and you will know exactly where they are. There is a way, I think this is underlying the way in which all these projects are being run. There is a way in which people of this country are being villainized. We're being constantly told that if you're not under surveillance, if we can't see all your data, if you don't listen to what we say, if you ask for the right to privacy, why would you want it unless you're doing wrong? So the way in which the state and the law is looking at people is very significant. Justice Sri Krishna is here. It's an interesting shift in language that happened in that committee report, where the idea of I forget what we used to be called earlier, but calling us data principal and data fiduciary. I can't hear you, sir. You have to unmute yourself.
No, you're muted.
Yeah.
The expression data subject was changed to data principal because we are no longer subjects.
Correct. So, and given that we are not subjects at all, we are certainly not principals. It's just that our data, so it was these are euphemisms that help in just shifting attention away from where it needs to be. We were data subjects at one time, and now even that has been taken off. It's important to remember that in 2012, the central government had already passed, they already had a policy document where they said any data that is residing with any department or any ministry, it's the property of that department or that ministry. So my data becomes the property of some ministry. Also, it is important that the battle that happened for the right to privacy and the battle that happened against the UID project, that was the fundamental axiom by which we were driven is this. The Constitution is not about the power of the state. The Constitution is about the limits of the power of the state. In the relationship of the state to the people have rights and the state has limits on its power. When we read the DPDP Act, you can see that's completely thrown to the winds. And that is one huge problem. I don't think I don't want to take too much time at this stage. We can come back. But just to globalize this issue too, there was a recent discussion on what is called the Great Replacement in Europe. That across the world today, we are saying we don't want immigrants, throw the immigrants out. And I think Trump has made it so blatant that it's easy for us to see, what that means. But in a story that was done on Europe, they found that some of the big tech people like Peter Thiel, like Elon Musk and others, they have been engaging in Europe, asking those parties who are anti-immigration to actually throw all these people out, throw out the immigrants. Now, we know that there is a history to how immigration happens. We know the kind of plundering and looting of countries that have happened, that people seeking, better pastures and running away from oppressions of various kinds land up in places which promise a certain amount of freedom and a possibility for an economy. And that now they want a great replacement to happen. So what they've said is, what the story says is that actually in Europe, there is a declining birth rate. So they need people. In fact, in a very telling, site visual, they show you how in Germany, in one hospital, where they were being told you shouldn't have immigrants, they have all the staff, that is the staff and the doctors and the nurses all line up along the staircase. And one by one, the immigrants start walking out. And what is left is just a bare, 5 or 6 or 7 people. So you won't have anyone if you don't have immigrants. I mean, many countries will suffer without migration. What is it that seems to be what the big tech companies big tech people like this are wanting? Those who don't want those who don't want immigrants, what are they going to replace it with? So it seems like there is a proposal for another great replacement where people will not be needed. It will be machines. It's robotics. So we are now being asked as human beings to compete with robotics, with robots, and being told that you are irrelevant because this can do your job better than you can. And to allay any fears, they say, oh, yeah, actually jobs don't go. You just retrain yourself for something else. And we know that that's not true. So I think when we think about all of this, so in NatGrid, I would also just want to add a couple of things, which is CCTNS, Crime and Criminal Tracking Network System. In criminal law, we always say that if a person commits a crime, if they commit an offense, they will be tried and punished for that offense. When they've served their sentence, they can go back and find a life again. It's not like for the next 7 generations, they're going to have this tracked to them. But here you have CCTNS where it will reflect, wherever the person goes. And it's important to remember that one of the key things in this has been putting the number in every database for not only for trackability, but also for aggregation of data. We also know that now in many states, they've been doing, first they had the individual IDs. Then, of course, you have a multiple set of IDs. Property will have an ID. I think cows have IDs, elephants have IDs. But also you have, farmers have separate IDs. Their land will have a separate ID. So you have, this idea of IDs proliferating everywhere. But this is about ubiquity, putting it everywhere and then making it easily trackable. The idea of cashless, the idea today when they are pushing it, saying that if you do digital transactions, then you can get yourself credit because you leave digital footprints. That is a very significant thing. And I'll just say just a couple more things. One is that when the Supreme Court passed a judgment in 2018, where they, it was in my reading of it anyway, the majority judgment is a deadly compromise. You can't say, people have brought evidence to us that people are dying because of this, but the government says it will take care of it. I'm sorry, that's not the job of a Supreme Court to be accommodating of the government. It is to actually reinforce the rights of people. But you find that at that time they said private companies should not be using this database. Private entities should not be using this database. The moment the judgment came, the government made a promise that they will be taking care of that. And in 2019, you bring an amendment. And after that, there has been a proliferation. In 2020, there was an idea of governance, all these systems being for good governance. In 2025, they have removed that as an overarching clause. Now, ease of living, so that, any entity can ask the government for permission to be using all these databases. And the government is liberally giving it because in 2021, there was another 2.0 conclave that was held where all the people who are, great pushers of this, of the project all got together. And Ramsevak Sharma was also part of the first committee, but has been mission director for a very long time, says that why is the UIDAI treating it like they have to provide, they're preventing, they're like gatekeepers of the use of this UID database. You should be fostering the use of this because we are looking at moving towards towards a digital economy. The idea is economy on the one hand, global aspirations, on the other, using the language of national security. And I just want to end with saying this, that the way the data is being collected, the way it is being proliferated, the way it is being handed over to all manner of people, the truth that this is non-rivalrous, and therefore even if it gets filched from, even if people are stealing this data, we may not even know. All of these represent an enormous national security risk. But it is not only this. It's also bringing in all these data centers everywhere. They are coming with a whole set of problems, and we are looking at proliferating these. I think, there is really, there is no thought, but a lot of ambition in these projects. And I think as people, which is why I was very happy when you said, will you come? Because I think as people, we have to start thinking. The state is not doing thinking. The state has too many ambitions. So I'll stop with that.
Thank you so much, Dr. Ramanathan, and for continuing the theme of, as Mr. Gupta set out, of examining these issues from a political economy lens, because oftentimes the legislations itself, and particularly, as both of you pointed out, vague phrasings, they obscure the grander design of how these things work together. For instance, Mr. Gupta mentioned exemptions for government and for AI. You, on the other hand, mention narratives around anti-immigration. And one may perceive these things as unrelated, but then it dovetails together when, like, for instance, a couple of days ago, Chief Minister Devendra Fadnavis declared that they would like to develop a tool, an AI tool that will help detect Bangladeshi immigrants through speech patterns and such. So seemingly disconnected things are actually connected in a broader design when you examine things from this sort of a lens. So I really appreciate your inputs. We'll move on to our final speaker of today, Mr. Justice B.N. Sri Krishna. Justice Sri Krishna, as a quick intro, obtained his LLB and LLM from Government Law College in Mumbai and the University of Mumbai, and enrolled as an advocate at the Bombay High Court in 1962. He was designated a senior advocate of the Bombay High Court in 1987 and was appointed as an additional judge of the Bombay High Court in 1990. Notably, he was a one-man commission that inquired into the Mumbai riots of 1992-93, and he eventually served as a judge of the Supreme Court of India from 2002 to 2006. Since retiring, Justice Sri Krishna has headed several commissions of note, such as the Sixth Pay Commission, the Committee for Consultations on the Situation in Andhra Pradesh, and notably and very relevant to this discussion, the Committee of Experts to draft a data protection framework in India that was set up back in 2017 by the Ministry of Electronics and Information Technology. Justice Sri Krishna, we're very happy to have you on board with us. I'll hand over the mic to you.
I was not trained to be a social activist. I was trained to be a lawyer, simple. Then I went on to become a judge, a job of a judge, which I managed to successfully complete after 16 and odd years. It's always the job to hold balance equally, notwithstanding the criticism may come from the one side or the other side. The judge is always buffeted between two criticisms. It is his job to hold it in a balance. With this background, now let us examine all the issues. Apar has done a brilliant way of presenting the historical evolution. There is no doubt about it. I have absolutely no call. Now the next question is, what has the law done? My belief, and I strongly hold this belief, has been that everything that has been done in this country or anywhere else in the world, from whether it is technological invention or law, whether it is invention of fire or invention of the wheel or computers till the computing artificial intelligence, was intended for what? For benefiting the human being, for making life easier for the human being, for making the interaction in society more comfortable, and ultimately, of course, the goal is happiness. There is no escape from this saying that. Now test it from that angle and see whether this law is good or bad. Now, because otherwise, you can't make a law based on theory. It is all right for theories to be expounded, but the question is, how the hell does the law work? That is what you have to consider. Now, I'll consider it from that point of view in a purely legalistic manner. I have always been of the view that if you want any law, the law has to, I always have said that it is in the form of a triangle. At the apex is the citizen, the individual. On one side, the state, which is in theory supposed to guard the individual's rights, and the other side, you have trade and business, which has to develop. And if you can't make this, but you say, no, only trade and develop, then you are criticized as a person who is an expropriator, what the British did in colonies, etc. Or if you do only state, you will be equated to the communist regimes or Hitler's regimes or Russian regimes during the communist regime. Therefore, if you are a democratic person, if you have a democratic country, you have to ensure that the three apices are properly maintained in their balance. Now look at it from the law from that point of view. That is the whole object of the law. If it has failed, it has failed. If it has not failed, it has not failed. Now look at it. I look at it this way. Fundamental rights are not given to us by the Constitution or the Supreme Court or nothing of the sort. Fundamental right is mine. It was born with me when I was born. Constitution only says, hey, if you are going to some way shorten his right, bridge his right, breach his right, you can do it only in this fashion and no else. If you do it this way, you will not be accused of coming out with a law which breaches the fundamental right. So that is all that the law can permit. Supreme Court did not give us fundamental rights. Please don't be under that misconception. Supreme Court, after a lot of argument, recognized, hey, this is also a fundamental right emanating from Article 21. That is all that the Supreme Court did in Supreme Swami's judgment. It is, Apar was right in his historical evolution of Aadhar and all that. That Supreme Court, during the arguments in Puttaswamy's case, some judge very innocently asked this question and said, hey, but what is the right about privacy in this country? What is the law about it? And everybody looked blank and said there is no law. That is why there is post-state a committee appointed. I was given a telephone call by the Prime Minister at 10 o'clock at night and said, we are appointing a committee, please accept it as chairmanship. And on Tuesday morning, we have to go and tell the government. That is how it came about. The committee was set about in an emergency situation. That's a matter of history that can go away. Now, what does this law do? I look at it, this law, I don't mean law in general or law was of deep data protection or privacy, which was thought of as originally. This piece of legislation which stands today has been passed by the legislature. It intends to say, hey, if you want to curtail the fundamental right of the citizens, this is the way you go about. So this is the law which tells them how to short circuit, how to shorten the fundamental rights of privacy. It is not the law which says, hey, you can't touch your privacy unless you follow ABCD, which is what we had said originally in the report. If anybody remembers the report, it's also part of history and everybody has forgotten it. Now that is why they said, we are not deciding it, you come out with a separate law. If you remember, Usha will remember that is what it had said originally. Now, we did not say that you bring that thing into this law. Now, what does this law do? This law, first of all, says the government is my bap, which was our thinking during the British region and which has continued till today, unfortunately. The my bap wants to take away anything, you can't oppose it. Take it away. The my bap doesn't have to give you a reason. Therefore, there is a section 33 which says the government may exempt all departments, any of the public authorities, any of the government companies from all or any provision of the Act. So tomorrow a Babu may say, hey, all provisions of the DPDP Act shall not apply to ABC or all the government departments. So what is the law? What is the purpose of the law then? Now, therefore, we are at the mercy of the government that we will be told, hey, you cannot do this unless you come back to us and take permission from us. No, that was not the intention of the DPDP Act. And Usha was mentioning that there was no concept of privacy at all in India. Sorry, madam. Go back in history. Go back in history. I remember my grandfather used to tell me one verse. I forget from where it is been picked up. Someday I'll find out from doing some research. It says, Ayurvittam grihachidram mantram aushadha maithune danam manapamanaucha nava gopyani gopayat. These are the things which have to be kept secret. That is the concept of privacy we had. Now, there was no government which was going to protect it or exploit it. This is the concept that we had in India. Now, unfortunately, colonization removed all these concepts. We started thinking only in terms of what the Western world thinks. Therefore, we thought, oh, there is no concept of privacy in India. Of course, this is the privacy. Have you ever seen any old man of my generation or even earlier than that disclosing his age? In West only it is the ladies whose age is kept secret. In India, everybody's age was a matter of confidence. It's a matter of secret, privacy. That is the concept of privacy. And sexual activity. In England, it is, in Western countries, it's a matter of a badge of honor to say, I have got this sexual activity. In India, it has been still kept under the concept of privacy. Anyway, that is neither here nor there because we are now concerned with the act. Now, what does the act do? Every act has had a regulator. A regulator is somebody, albeit that it is an executive authority, but with operational independence and subject only to overriding policy considerations from the government, the executive. Now here, there is what is known as a board. And the minister made a parliamentary declaration or elsewhere somewhere in public, he said, this board is not even a regulator. So not even the status of a regulator. That means what is it? It's a board which is entirely captured. Look at the composition. As it is, the act does not hardwire who should be the chairman, what should be his qualification, who should be the member, what should be their qualification. Anybody if the government thinks tomorrow that I am an expert on data privacy, I can be made a member. If they think that Apar is an expert on data, they'll make him a chairman of the board. What does the board really do? Nothing. The board is ultimately, as I called it, a captured entity or a stooge of the government. Now, if that is so, what have you done? You have created a situation where you have to appeal, as they say, from Caesar to Caesar or Caesar's wife to Caesar or Caesar to Caesar's wife, which is a greater authority. That is what they have done. So there is no methodology by which, apart from going before the High Court and the Supreme Court to say, hey, this is my fundamental right. This has been infringed in this manner. And what is the exemption that have been given apart from the general exemption to all government entities? And today, the government is the bigger holder of our data. More than 85 or 90, I think Apar will be able to tell me, 85 or 90% of the data, or probably even more, is held by the government, not even by private entities. Now, what do? First principle we advocated was that the government entities and private entities should be on the same page, same level as far as protection of data is concerned. That is one big rupture. They have taken away government entities. My Baap Sarkar is My Baap Sarkar. You can't ask questions of My Baap Sarkar. This is the concept that is continuing through today under this act also. And of course, the general things about consent, whether consent. Now, consent, I always felt that, look, if you want to do something that pertains to me, you must have my consent. There is absolutely no escape from that all over the country, all over the world. That is the basic. But it is a necessary condition, but not a sufficient condition. My consent is basic. Now, there may be circumstances when consent may not be possible. Now, you have to waive it in such a manner that my fundamental rights are protected. Now, here, 3 mantras. I need your data. Without your consent, I'm taking it for what? In the name of sovereignty, in the name of security of state, in the name of good governance, in the name of something else. This is not, all right, you want to take it in the name of sovereignty? Please tell us what sovereignty is. I don't know. Sovereignty is as good as the concept of Brahman in the Upanishads. I can't define it. The British Parliamentary Commission has gone on record and saying sovereignty is something we can't anytime define. That Butler Committee said it. It's something that we can't define it at all. So if some Babu says Tomorrow, Usha Ramanathan's personal data should be taken away in the name of sovereignty. She has no recourse. To whom does she go? He goes to data board. The board will say, sorry, it is not our function to deal with this issue. Then she goes to the High Court or Supreme Court. The judge will ask you, madam, what is sovereignty? First you tell us what is sovereignty, and then we'll test whether it is infringing sovereignty or not. Alright, it should have been the other way around. Don't make the judge do it. The judge has to test whether it is the definition and where action is fitting the definition. If you are missing a button from the coat, you take the coat and stitch a button. It's the reverse way around. Take a button and stitch a coat around it. That is precisely what this law does. Now, take any one of them, security. Now, there are so many of those securities. Everywhere, the concept has been defined in the act. That is why the legislature must always hardware the definitions. The definitions are not subject to notifications issued by the executive. If the definition is in the law, nobody can really go transgress it, number one. Nobody can issue a notification. Yesterday, I was reading a judgment where the Supreme Court has severely criticized it. Issue a notification and change the definition. Now, it is this definition that has to test your actions. It is this definition that has to test all your circulars and rules. It is this definition that needs to be applied when you go before the constitutional court and say, my constitutional right has been impeached. Now, that is the signal failure of this act. What does it lead to? It leads to simple thing that Usha was right in pointing out, Apar was right in pointing out. Whole lot of data is collected. Then data will be not necessarily about my name and my age, my biometrics, and then my girlfriends, and then their names and their addresses. All that will be collected and be used appropriately at appropriate time for appropriate reasons. What is this? This is exactly what 1984 said, no? I think I said it 1980. I also said sometime that you are taking us to the George Orwell situation. Now, openly it may look that it is so, but why did it happen? Look, let's go back to why did it happen. The bill, I'm not here to boast about my original bill, whether it was cheese or not. At least it was better than chalk. Usha will agree with it. Now, somewhere, when bad things have happened, you say, yesterday was much better than this. Like my grandfather used to say, the British Jamana was better than what is happening. Because he compared the consequences. I won't say that. Although I was born a British citizen, I'm not saying that. The point is, you look at what the British original report and the bill was, and you look at what has come out. I always have said this in all public lectures, all seminars. There is a very famous saying in Sanskrit saying, Vinayakam prakurvano rachayamasa vanaram. So somebody was asked to do Ganpati, and what turned out to be a monkey. So that was at least Ganpati, if not at least a semblance of a Ganpati. This is definitely monkey and nothing more than that. Because it does not allow us to emancipate, become free citizens. It surely enslaves us much worse than what we were before 47. It takes us from 1947 to 1984. The 1984 book, I mean. So I think that there is enough scope for activists like Apar or activists like Usha to challenge it, and right and left after you remember Apar, you were part of that single judgment, no? The same argument will apply to every section. And there is one fundamental principle in law, in constitutional law or constitution jurisprudence, that any act of legislature which is so vague and so much bereft of guidelines so that it can be utilized for an unconstitutional purpose is itself bad in law in constitution. That is liable to be struck down as a vague and excessive delegation of power. Now that is open at every section according to me. But again, as we say, aage ka parde par dekhiye kya hota hai, because we don't know, nobody has challenged it, somebody will challenge. Even that IT Act, till single judgment came with the bill, that young girl got up and challenged that section 65A or whatever that section was. We all thought it was great, good thing done by the Ministry of Electronic and Industry. So this, let's see what happens. And one more thing. Why did all this happen? This is important. The government, it's unfortunately the judge's job to do balancing. The government is not interested in balancing because it's one part of the vertex. They are not doing balancing. They are doing what they think is right. But when they are doing it, they're buffeted by vested interests. Now, all the tech industries, all the high-tech industries, all the giants, all the MNCs, they were the stakeholders whose consultation gave rise to this kind of thing. So this is the thing that comes out when you emphasize one vertex of the triangle as more important than the other two vertices. Now, if they are all balanced, there is a fundamental principle in mathematics known as the relative direction of movement. That could have applied. The relative force would have been something that balanced all three. It does not. It counterweighs our individual rights. It is heavily loaded in favor of government. Is the ultimate parting thought that I would put before them. My job was badly done. This is worse. That's all that I can say.
Thank you so much, Justice Sri Krishna, for those very candid remarks and for particularly contextualizing how we need to view our, especially for non-lawyer viewers, how they ought to view their fundamental rights, especially coming from you, previously sitting judge of the Supreme Court, explaining how we need to view our fundamental rights. I think it's incredibly notable. I think before we move forward, and I would love to take final statements from each of our speakers, but I think Dr. Ramanathan wanted to make one clarification at some point. I think you're muted.
I did. Justice Sri Krishna, I wasn't suggesting that we don't have a right to privacy or we didn't care. I was saying this is the argument that was made to say that nobody talks privacy and therefore nobody cares here. And it was our task to then go and establish. I mean, we had to find the language because when you don't lose, sometimes it's only when you lose it that you need the language to say something. I mean, I know in the women's movement, we discovered patriarchy because we were being oppressed terribly. If it hadn't been there, maybe we wouldn't have bothered with the word. It's not like the word didn't exist.
Look, but, if I don't feel hungry, I don't think of my wife at all. This is unfortunate in life.
Oh my God,
if that's I don't feel hungry. Shankaracharya himself said, no, Kshuda Trishartha Janadim Smaranti. It's only when you are hungry, you'll think of your mother. Amma, give me something to eat. Till that time, you're happy doing whatever you want in life.
And one other thing, sir, is that I get what you're saying about judges having to balance. But I thought the idea was that you hear two sides. Right. And then you make an assessment of who's right, where the right lies. It's not just balancing 2 points of view. It's right. So that's been your, and I find that in this, the task is always semi-done. It's like compromising with the state. So in one sense, in legal theory, we talk about it like it is only, the court is only relatively independent. It is not independent.
No, on that I have a difference about the concept itself. What is compromise? Compromise is balancing in such a way that it does not, one does not outweigh the other. That is compromise. What else is it? In fundamental theory of compromise is you give up some, I will give up some. Please understand.
I'll just explain that, why I'm saying it. In the context of technology, we are talking about two things. I mean, two major factors. One is the extreme inequality that exists, which means that you don't really have people with the same power standing before you. And we often say that there is a difference between impartiality and neutrality. When you see somebody who's very weak in front of you and you see very powerful interests on the other side, and you see that there, people are coming for their food or they're coming for work, they're coming for their monies, and there are on the other side all these big tech companies and the state, then it's not about being neutral, it's about being impartial.
That is being about that is a compromise. You make sure
it's not a compromise, sir. We'll disagree on that and leave it there.
I've sat on benches which are
That's okay. I sat on the other side. I have studied you for 40 years. So
I have given 10 years judgment, 16 years.
And I've assessed your judgments over 40 years. So we'll just leave it there because we don't. I don't think we'll agree here.
Because I have a fundamental disagreement with you at what is compromise.
That's fine.
Compromise is there is a person, lady who is on the street comes to me. And somebody, rich giant technological industry or big MNC says, no, I will not give. In that event, I have to necessarily lean toward the lady, irrespective of what the legal issues are, help her in reading the law in such a manner that she can bear. That is exactly what has been done. That is exactly what a judge needs to do. You call it balancing, you call it compromising, you call it anything.
We'll leave you with the last word on that. But there's one other thing.
Because I've done it for 16 years and there is no escape from that. I cannot change my DNA.
You can't insist that we have to agree. We can disagree.
I agree. I totally disagree with you. I agree.
Yeah, of course. It's a long story, sir.
Yeah, that's right.
There is another part of this where I was very interested to see your thing on social activists and what people do. Actually, for many of us, we've been professionals all our lives. I mean, I've been a professional law researcher for over 40 years now. But the idea really is about active citizenship. There are times, when the privacy case and the UID case was being done, there were a number of lawyers who worked with us. Not a person charged a fee. They were available to us night and day, because we had 7, 8 lawyers, we had to brief every day. They would be, anytime we went, they would be available for us. And one of those, and they would actually pay juniors who were helping us with the case because they said, we make some money, but these guys have to survive and they are working on this. One of those times I asked them, I mean, at different points in time, I asked different of those lawyers, I said, why are you doing this? You could be sitting and making all your money and walking away. You're actually spending so much time, effort, energy, money, training youngsters. Why are you doing this? And they said, well, if this case is lost, there will be no constitution. We are actually seeing what that means. We're seeing it unroll. So for many of us, these were acts of active citizenship.
Right.
I just wanted to clarify that. That's all.
Right. Before we move forward to questions, I wanted to invite Apar to share a few thoughts, considering he was the first speaker. Any responses or any interjections?
We should step towards the questions. My only limited comment will be that I agree in part to some extent that the draft which was given by Justice Sri Krishna was considerably better. If you look at it from the perspective of the creation of a regulatory authority, there's complete centralization of power in the determination, application of the law. And when the law is vague, it doesn't have ingredients, it means that the government can, through its own determination on a daily basis, provide exemptions under the data law as it is to one single company, by the way. The law
Yes.
permits exemption without any qualification of standards. So, on various matters, I would say it was a much more sophisticated draft. I do disagree, but then I do also understand that, the larger disappointment I'd just like to reemphasize is this. We have institutions in India which work, right? You have expert committees, you have court judgments, you have parliamentary processes. When all of that is disregarded, when a new law is brought in, and it
Correct.
is to a large extent portrayed in the popular media, in the tech policy conversations quite often, that this is a law which is simple, which eases the compliance burden, etc., etc. And it's a complete it's a complete marketing of the law, which is not going to take effect for 18 months, and even now there are further extensions which can be granted under it for 5 years. So a law which is passed in 2023 gets rules in 2025, and the notification timeline and the implementation timeline, we are looking for another decade. And what is happening in the meantime, actually, due to the data gathering practices, due to the data breaches, due to the increased amount of digitization in our daily lives, is being felt acutely by people who lack power in Indian society. Quite often, it is gendered violence through deep fakes. And here, if my image cannot be protected, which I put quite often on social media, it's not a problem. But for a woman, it's a problem because you have a large language model which can quite easily, and was permitting to a recent, till
Correct.
it was not fixed, was generating deepfake images of her portrayed in partial states of nudity without her consent. And this is a structural choice made in the data protection law. It will not be applicable for a long period of time. What happens to the welfare beneficiary? What happens to other categories of people who have been disempowered or are being targeted by financial fraud and scams? And this is happening on a daily basis. Why are digital arrests happening? Why are people again and again, on the basis of information which somebody has and then misuses, being emptied out of their savings again and again? This is a national problem now. And if we are to honestly examine it, it lies at the root of how we have failed to look at any kind of legal regulation, and and this is a choice we have made. A choice we have made in favor of a belief, I would say a theological belief in technology making our lives better. And we need to question, is it actually doing it? if we are so afraid of even accounting for its harms and then through a democratic constitutional process making a system for it. That's the larger comment I just want to make.
No, that's very astute point there, Mr. Gupta. And interestingly, and one of the questions that I had to all of you, and this is a broader thematic question, each of you touched upon the somewhat changing nature of the government's consultative process, as well as the prevailing narratives amongst the citizens, a certain lack of regard or lack of concern for these kind of issues, these issues seemingly being inaccessible or not affecting them immediately. I think Dr. Ramanathan in a few years back made a great comment at one of her addresses talking about how when you speak to a lot of people, they want to maintain their current technology practices and not question them, but on the same time, they also want all their rights to be preserved. So this is a two-part question, and I'm curious about your experiences, each of you, which is that first is how have you viewed the changing landscape of public consultations and how much of an impact they have on the legislations that come? And how do you anticipate, and considering the fact that it's that you've argued that the state often isn't listening to us, how do you think citizens need to respond in their, I guess, in their private capacity, in their dealings, in the changing landscape of this data economy and how it's governed? Perhaps Dr. Ramanathan, if you'd like to start with that first, and then we can move on to Justice Krishna and Mr. Gupta.
See, one of the questions in the box is also, you're willing to give your biometrics to, foreign countries, but you're not willing to do it here. I actually find that a red herring.
Right.
It's not, and the reason is this, there are many battles that we can have with our own state. And we have a right to our state. The state is ours. The state is, in fact, it is ours. We don't belong to the state. The state belongs to us. And so there are many things that we can ask of it. That's one reason. And the other is that, see, unfortunately, this digital era in India is characterized by lawlessness of the state. So at every stage, when they said mandatory, it will be voluntary, they made it mandatory. When the court said you should not insist on it, they went ahead insisting on it. It was not by accident. And it's very interesting that in the National Knowledge Commission, that's when everything went on, the e-governance platform was actually mooted there, and that's how we've come in. And you find that all these are being run as mission mode projects. So the UID, the NPR, these were all mission mode projects. And if you read the definition of what a mission mode project is, the first thing is that the state will be supporting it to the hilt. Whatever you need to do, we need to get this done. So the consequence is more important than the process. So if people lose rights in the process of arriving somewhere, that's okay in a mission mode project. And that's been part of the problem. Why is biometrics more of a problem here than somewhere else? Because in the Indian state is asking it of every person and then saying that when we wish to, we will ask you to identify yourself through that biometric. So all the people who are going for rations are finding that if their fingerprint doesn't work, then they don't get food. So and these were untested technologies and we knew it. When other countries are asking for our biometrics, it's one of many other things they keep in case you skip and don't come back to the country or whatever. They keep, and it has a psychological effect of making you feel the outsider. Our own state shouldn't be wanting us to be the alien. So, what I'm saying now is actually kind of parallelly to what you're asking, which is that how do you make public policy? Who do you make it for? Yeah. What should it be? And like Justice Sri Krishna said a while ago, all of this, any lawmaking, any judgments that are done should be to increase the freedom of people and ultimately happiness of the people. There is a sociologist who'd written recently in the Tribune who says that, today everything is characterized by fear because of this. If this doesn't work, you don't get it. If you don't go and log yourself in somewhere, then you're out of the system. If the system doesn't work for you, you are made to blame for it. So he says, how could we allow for this digital transformation to happen here, which is primarily a mover and shaker of fear? How can people be living, that there is something wrong fundamentally with that. There is something wrong in the way those policies are being thought of. And I think another sociologist, I just learned this recently, I'm still reading the book now, calls it soft violence.
Right.
It's not like you don't have to beat a person over the head with it. But if you say, okay, you come, let's see, if it works, it works. If it doesn't, sorry, you can't open your bank account. You can't take your money out. You won't get your food. You can't travel. Every day you live under this. And that's soft violence, which is being practiced across the board. Who are the people it benefits? I don't know how much it benefits the state. I mean, the state feels like it's in control, but corporations are benefiting hugely, and the big tech is getting the best out of all of this.
Right.
What are we thinking?
Right.
So policy has to account for this, that there are extreme imbalances of power between the people and the corporations, that the state has to be, figuring out how the freedom of people will get enhanced without allowing for these corporations to take our lives over. If the state starts aligning with those corporations, then it becomes a huge problem. So lawlessness and the relationship, corporate state relationship, that these two are major things which will not allow for any policy discussion, because that's not what's being looked at. I mean, you're looking at something else.
Right. It's interesting. It also, I think it relates, I don't know if it's the same concept you're referring to, but also relates to the idea of slow violence that was propounded by Rob Nixon, and how...
Yeah, that's the one I'm talking
about. Right. Justice Sri Krishna, I wondered if you had any comments on that too. And additionally, I was curious, since you mentioned it in your remarks, and someone's brought it up, about how the Act does set up the Data Protection Board of India that's meant to keep things accountable. How will that stop a misuse of personal data? One of the viewers is asking. So I was wondering if you could respond to what was said now, and also talk about the accountability inbuilt in this Act.
But two things, general exemption under Section 35. So Data Protection Act does not come into the picture at all, because if the Act doesn't apply, what will that board do? Number two, if the Act applies, then the board consists of all government nominees.
Right.
I mean, these are the days when we have started even suspecting court judgments.
Right.
Now, are you going to be very happy about government nominees deciding my issue about my fundamental rights?
Right.
I don't call it my fundamental right, my privacy right. So technically it is my fundamental right. This is one thing. Talking thematically, and at 35,000 altitude, not on the ground. See, ultimately, my great-grandfather walked all the way from Karnataka to Kashi, because there was no other means of going. Now, if I have to go, I pick up a plane and go. Notice, plane is a technological advance. Plane has a lot of inherent, we saw the Air India crash recently. 300 people died on the spot. Therefore, technology never comes without a cost. And that cost may be human cost also. Let me accept it straight away. Therefore, are we going to say shun technology and go back to what our grandfathers were? Or we go back by Gandhi's theory of working only in the villages? Fine. If that is one way of looking at it, that's a policy everybody accept. Democracy should accept it. I'll be happy to implement it in my life. Otherwise, if you say no, technology is to be accepted, then the question is, this is where I told of balancing. You take the technology, ring fence it with whatever evil effects are there, they don't hurt the people. That is the analysis, that is the policy that should be followed. Now that it has not ring fenced, maybe bad thing about this act or that act. But the policy is technology cannot be avoided, because whatever you do, technology is going to overcome your life. Today we are in a situation, AI is going to run our life whether we like it or not. Our only difficulty is how do we ensure that its evil effect does not affect us. Now come out with think about it, come out with solutions. You cannot say I'm not, otherwise you will say I don't want electricity at all because electric shock, people die. I'll show you statistics of how many people die in our own country. How many people die because of air crashes? How many people die of vehicular crashes, car crashes? Are we going to abolish all of them? Let us be reasonable.
Right.
We need it, but whatever its evil effect is, stop it in whatever best we can. Beyond that, it's Bhagwan ki ichha hai.
Dr. Ramanathan, if you have a direct response, and then I can come to Mr. Gupta.
Yeah, just a quick one on this inevitability of technology. So there's a recent book that's come out by Karen Howe, and she has a passage in a chapter titled Dreams of Modernity. She says, in their book, Power and Progress, MIT economists and Nobel laureates Darren Acemoglu and Simon Johnson argue that every technology revolution must begin with a rallying ambition. It is the promise of a technology benefiting everyone that puts in motion the long journey of amassing enough talent and resources to turn it into reality. After analyzing 1,000 years of technology history, the authors conclude that technologies are not inevitable. The ability to advance them is driven by a collective belief that they are worth having. The irony is that for this very reason, new technologies rarely default to bringing widespread prosperity. So they don't result in widespread prosperity. Those who successfully rally for a technology's creation are those who have the power and resources to do the rallying. The idea of inevitability is being fed to us. It's not, if you don't accept a certain technology, it does not mean we are going back to cave age. In fact, I find that the way these technologies are being used and the kind of power that is now being vested in a few people who want to control all the policies of the world, that is driving us completely out of, the existence to which we brought ourselves now.
Right.
And one quick one, I think we should factor in climate change at some stage when we're thinking about what technology has done in our lives. But we can do
That's
that
exactly
in
what I
another
said. Ring fence the people against the evils of technology. That's the last word. To
Right.
say that technology will never bring prosperity,
course.
are you sure you
Nobody
have
says that, sir.
when you want to travel by a plane, Mrs. Ramthan?
No, but plane is a problem, so let's not go there.
Why not? You wait, all right, inside the city,
Climate
don't you
change
travel
is-
by a car? A car is technology.
It's a problem.
It has
So
evils. What is
that's
happening
for
in
another
Delhi?
session.
What is happening in Delhi? Pollution is there. Therefore, cars should be banned from this country.
No, not
Come
at
on,
all.
Let's be reasonable.
Right.
It is one thing. Look, this is exactly why I said a judge's duty to balance. I agree with you. If you go back to Gandhian principles, staying in my village, drinking the pure water, not that the rivers are very pure nowadays, drinking the pure water without all evils would be ideal. I don't want to wear a jacket at all. I would be happy wearing my angavastram and walking around. But is it feasible in today's country? Can you do that? Hello?
Right.
Let's be reasonable. That's all that I'm saying. And reasonableness is an element of compromise.
So you
It is a part and parcel of judicial
insist,
discretion.
because then I'm forced to respond. Let's just say
No,
that
if you want to have a
nothing
debate,
is a binary.
I am willing to spend the entire 25 minutes of yours and mine in having a debate, because no
Yeah,
point in
both.
quoting from somebody elsewhere. Look at practically what is happening. Sociologists in the world may quote anything. Think it's what's happening. Are we in a position to say we'll walk around on the streets? None of your
I'm
argument
really
is
not
wrong.
getting into this. I don't agree. I don't agree.
Why
that
can't
there
you?
is a
This is
binary.
exactly a practical problem.
No,
If you
I
come back
don't.
from 20, please,
Sir, I
if you
don't
come back
agree
from
that
your
we
altitude to
exist in binaries.
realities of life, you'll have to answer them.
I-
I'm not talking as a judge. I'm talking as a common, ordinary human being. Please think is what is happening in life on the ground level, not really in the books in somewhere published in America.
No. Fair enough. I think if we move beyond the scope of generalities,
Yeah.
I think you agree a
just
lot
give
more
me
than you.
Agreed.
Ronak?
That's all. So I am not here to argue generalities. I am not an expert. I don't have a PhD in social science or something like that.
I have.
I am a common human
do it.
being. I am common human being who has faced life probably more than all of you together.
Right.
And I know what it is.
Right.
That's okay.
Yes,
We'll keep it for another day, Ronak.
As we say, each for himself or herself. That's right.
I'd like to try and get Mr. Gupta into the discussion and bringing it back to ground level impacts. And a lot of the questions that are coming up in the chat are questions about how this could affect them, how because all three of you have highlighted a degree of a lack of power that this leaves people with, and a degree of opacity with questioning the governance structure. And Mr. Gupta, you also highlighted things like, and not just today, but in your previous writings, the potential chilling effect on speech this can have for journalists, as well as the implications for RTI and questioning the government. I was wondering if you could expand on that a little bit and in some cases educate some of our viewers about what the tangible impacts can be of this.
So, thank you so much. I'll just, again go back to the law and again, like a lot of the comments which I'm making, which are referring to specific provisions of the Act, they have been analyzed by my colleagues in a very detailed brief, and I'll be posting a link to that in a comment on this YouTube video. The first thing I'd just like to touch upon is the exemption which is given to AI companies. So this exemption has come about at the last stage of the law and was made notably to permit AI companies, which are primarily within this conception of this exemption, generative large language models such as ChatGPT, which is a platform and then has models which are running like 5.2, etc. Or Claude has its own, or there's Llama for Facebook, which have been trained on web data. So basically, they have scraped the entire internet, and on the basis of which, or even books without permission, okay, and on the basis of which this large language model through big data training has basically come to provide these magical powers of text generation, image generation, video generation. And here, the Digital Data Protection Act states that anything which is made public is not covered by this law. However, this contradicts the understanding which is being provided by Justice Sanjay Kishan Kaul in the Puttaswamy judgment, in which he gives a very nice practical example, in which he says that just because I publish something on Facebook, right, and I have about 300 friends who are able to see it because they are my friends on Facebook, does not mean I want the entire world to see it, right? It may be my birthday celebration. And I certainly don't want AI to train on it, right? That's never something which has been in my conception. I should be able to freely consent to all of this. However, in the understanding and the reading of the data protection law, this is public information, which is why, and this may not be also correct. However, the law has been structurally created in a way to fuel the expansion and unregulated expansion of these generative large language models and their pervasive data gathering on a continuing basis. Even if we accept that the law through its exemptions and the government won't exempt it, it's exempted structurally. And this is very important for us to understand in practical consequences of how it's visited. For instance, the entire deepfake problem, where does it start from? If the model itself illegally has trained on my face, right? Or somebody's inputted into it, shouldn't be permitted. These are conversations we need to have rather than raising our hands and saying that there's some magical value which is being provided by this technology that we should not even touch this conversation.
Right.
I'm saying the cost and the benefits need to be objectively analyzed at the very least through choices in law. Okay. The second thing I'd just like to mention very, very broadly is that when we look at the data protection law which is being made, it is to equalize the power which emerges in a digitized society between us as citizens and individuals and state power and corporate power, right? Because quite often, the basis of a digitized society is a pervasive, continuous collection of our actions and even our inaction, even when we are resting, right? So all this information which is being gathered by them in the certain conditions has been provided certain rights that you should provide a notice, there needs to be a consent, etc. However, going back to what's been touched upon, firstly, in terms of an enforcement timeline, the exemptions which are there, even if you match the rules alongside it, it deepens the state and corporate power, which does exist to a large extent. State power is very, very clear in all through it. There's an exemption which has been provided. And on the contrary, this is the only data protection law which places an obligation on me, the individual and the citizen, to provide my full and accurate details each time I'm asked about it from a data fiduciary, which means even a private company. So this needs to more data collection, and we need to think about it in context where we possibly enter the wrong birth date some days because we don't want to be wished on our birthday. And that's completely fine, right? Ronak, we don't want everyone to know our name. Why should we? If we're just trying out something. But this is
100%.
what the law is saying, and there's a penalty. There's a penalty. This is the world's I say this with confidence. This is the world's only law which has placed a duty on me as a data principal
Right.
and a penalty on me as a data principal. And this is the aspect which needs to be examined as well.
Right.
Finally, just like to end with one final thing on this law. Quite often, we want a law which is enforced. A law cannot be enforced which has a complex regulatory environment if there's no regulatory authority. And this matches a broader post-liberalization. Even post-liberalization, there was a recognition that complexity required regulation and autonomy away from the political interests of the day. This is why we still have the RBI, we have SEBI,
Yeah.
etc. And there are questions on their autonomy, but they are still to a certain extent having the depth of knowledge. You could possibly even question that on the basis of a daily application of what that public policy choice needs to be and reflected through a government notification rather coming through directly from the government authority.
Right.
And here, let's just like to say, not only is there no regulatory authority, which is the regulatory authority? It is mighty. It's that ministry.
Right.
And again, going to the point which has been made, the Data Protection Board is only a board which adjudicates data breaches. Firstly, as has been stated, if a public sector entity is exempted from it, it will not levy a penalty. If a private sector entity is complained against, it may go slow, it may go fast. This is not only because the staffing and the appointment of the board is by the government. If the accompanying rules are also seen,
Yes.
one, it is a digital office. There is no physical establishment. Secondly, the salary is determined and given by the government. Even the leaves and the allowances are directly linked to the central government rules. And what are the central government rules? You know how coercive they are. You need to apply for station leave sometimes if you go outside the city from which you are there. And who do you apply it to? The ministry,
Ministry.
your boss. So they
Right.
are your boss.
Right.
And guess what the Mighty has? I invite everyone at that right now on the webinar to go to the Mighty website and click on the number of or smaller institutions which report to it. NIC reports to it, the virtual backbone. The NEGP projects, the national e-governance projects are also housed within it.
Yeah.
So when all the data is being gathered by that same ministry, which is the regulator, which is the appointer of the adjudicatory authority, and also exercises the power, we are expecting, I would say, a pack of wolves to guard the hen house.
Right. No, extremely valid point, and thank you so much for that explanation. I would invite all the participants to evaluate this for themselves, look at the Mighty website, and go through a lot of IFF's detailed reports. One other question I have, and a lot of people have, and this is for the whole panel as well, and this speaks to remarks that Mr. Gupta and Dr. Ramanathan have made about the nature of NatGrid and surveillance and the potential red herring of security that can be used to accumulate data, as well as to the points that Justice Sri Krishna raised about how to strike balance and reasonableness. So a lot of people argue that in the context of our broader geopolitical situation, you need to have a fair degree of powers that the government needs to have in order to thwart terrorism, in order to thwart threats, and therefore giving them to a degree a carte blanche is valid, or protections are valid. I was curious to know each of your perspectives as to how would you balance, or how would you articulate to citizens about balancing this right between surveillance and their own rights and their security. Mr. Gupta, you can go first. Yeah.
Can I go first?
Yes,
Yes.
absolutely.
We would just like people to step back. Whenever national security, terrorism is mentioned, which is a valid and legitimate concern, they need to step back. What is the proportion of lives which are lost and terror which is struck in our hearts on the basis of the act versus the inaction and lack of accountability by government, and place that in the larger experience of our lives, in which our cities are terribly decaying, polluted, and makes life, in fact, inhuman for people who cannot insulate themselves on the basis of their economic privilege. What is the air? What is the water? What is the food? And what is the loss of life being caused due to this?
Right.
Where should the public resources and our attention go towards? And I'm not saying one problem takes away from the other. I'm just saying the number of lives which are being lost in northern
Right.
India due
Right.
to air pollution needs to be considered, because if you are implementing a data intensive technology, and there are enough reports which are coming, because India wants to become the second biggest data center in the world, where will that energy come if the energy is primarily coming from coal-fired plants, and there are rising issues which are already being caused even in water contamination? I want us to think about these things.
Yeah.
We have to think about the problem holistically. Secondly, I've written a recent op-ed in the Hindu, which does draw a little bit from Usha Ramanathan's work. She's been documenting the issues with NatGrid even before me.
Right.
When the state, when there was committee was set up by the Maharashtra government to investigate the issues related to how did 26/11 happen, it discovered that a police force was supposed to respond to a terror attack which deals with day-to-day policing issues in Bombay and is not structured for a response to a terrorist incident.
Mhm.
The recommendation around that time was that they need to be given provisions. They had not had firing practice for 2 years. So, what are the problems which are being fixed by technology needs to be matching the solution which is being proposed, which is NatGrid. And third, this is the larger, much more legal point. Our intelligence apparatus does not answer to parliament, it only answers to the political executive. There's a very high deference to securitization in the courts. I'm also a lawyer in the Pegasus case. People can check the progress of that case, in which reportedly spyware was installed not only on journalists in India, but members of the Indian opposition, even judges of the Supreme Court, even cabinet ministers, thereby undermining the very structure of how our democratic polity works. This challenge is very big. So when we hear about securitization, there is no underlying law, there is no safeguard, there is no definition, there is no accountability,
Yep.
which is why I'd go back to what I said initially.
Right.
We have to think about it from the perspective of asking for accountability and keeping it proportional to the life which is lost and the attention which is quite often being taken away from the real problems of everyday life. Because quite often, let's be honest, securitization does offer an insulation to a person who says something about we are doing it for you to keep you safe from
Right.
asking them questions about many other things in which there's a clearly something they are failing to do their public purpose.
Right. And I think it really it pairs up with exactly what Dr. Ramanathan was saying earlier about like the extent to which we are affected by slow violence versus the primacy that we give to what is perceived as like faster or quicker violence via this narrative of securitization and terror. So balancing our perspectives would be very important. Justice Sri Krishna, I was curious if you had any response on that too, particularly in terms of balancing proportionality when
Exactly.
looking at this.
Look,
How would you articulate that to the average citizen?
proportionality test is very simply this. You have a fly buzzing around you, bothering you. You deal with it effectively. How do you deal? Either you swat it with your hand or use a fly swatter. But if I were to give you some kind of very complicated machine which will throw 100 bullets a second or something like that, that is ridiculous.
Right.
You don't, our people were wise to say, don't throw away the baby along with the bath water. Change the bath water if you want, but don't throw away the baby. So basically, the question is, any technology, does it really produce some result for you which is benefit of the human being? Along with it, does he have any side effects which are going to be harmful? Try and see if you can balance in such a manner that benefit is maximized, the results, evil results are minimized. Or put and ring it, friends it in such a manner that only take the good effect and take anything for that matter, nuclear technology, your Air Force, bombs, all of them are, take a sharp kitchen knife, which every housewife uses. You can use it for cutting vegetables or stabbing somebody. Therefore, do you ban them? Except on your airplane, that idiot will take away your nail clipper also. That is disproportionality.
Right.
Therefore, there should be a proportionate, that is the doctrine of proportionality, Supreme Court advocated in all the judgments and also reiterated in Puddaswamy judgments.
Right.
Therefore, there should be an attempt made at the highest level in the government with the help of all of you, ladies and gentlemen, to emphasize what are the evil effects, identify 1, 2, 3, 4, 5. What are the good effects, 1, 2, 3, 4, 5. Which balances which? And then take a call on that. That is very rational thinking. It doesn't require a lot of people telling us lectures from podium.
Right.
This is exactly what a judge does.
Right.
Could take any technology issue. This is the first question he will ask you. What is it? Does it do? What is it? Does not do? How does it help you? On this question of NatGrid and all that, I agree with you. It is intended for a good effect, but ultimately your Pegasus told us what happened. And in the Pegasus manner, The government did not even file an affidavit. They refused to file an affidavit. And the
Right.
Supreme Court said, okay, we don't want to file an affidavit. We don't want to force you. If that
Right.
forced it, then things would have been better. Therefore,
Right.
I agree with you. I agree with Apar. There should be a question of methodology of ascertaining accountability. Now, I was reading in the newspaper that the chief economic advisor has suggested that the RTI should be restricted. The act should be amended so that questions cannot be asked immediately.
Right.
Now, in such hands, you don't give technology, I grant. See,
Right.
the question is not whether today's government is good or today's government is bad. Basically, what is the issue? Now, how do you resolve the issue?
Right.
Take,
Dr. Raman,
take
yeah,
the,
sorry.
the good and the bad come together. We cannot help it.
Right.
It's life, good and bad together. And
Right.
any reasonable person will say, I'll maximize the good, try to shun the good, bad, or put some methodology by the bad effects are eliminated. And that is what a good doctor also does, no? He gives you a strong medicine where you require, but he says these are the side effects for which he'll give a secondary medicine. And this goes on in life, whether technology or otherwise. I cannot say doctors are all fools, they don't have to prescribe medicine.
Right. Thank you so much. Dr. Ramanathan, I was wondering if you had anything to add about this discussion and how we understand proportionality in the context of security versus surveillance and the narratives that go along with that.
Yeah, I'll just add one element to this conversation on proportionality. Proportionality is not only in relation to the harm that is sought to be stopped. It's very importantly also in relation to the right that might be infringed on. So if you take away a privacy right, because you say that's the only way I can reduce harm and call it proportional, it's disproportional because the right is lost. The right can't vanish.
Right.
So that's another element of the doctrine of proportionality, where we have to preserve the right. So when they say reasonable restrictions in the Constitution, it's not reasonable in relation to whether we think it's a way of limiting the extent to which the state can go. And I think it's also important that even in this law, all the exceptions that are provided, say you take something like free speech, and they'll say there are all these exceptions. The government can't make any rules beyond those exceptions. But what they do in these laws is they just mention all national security, then I don't know, I mean, I can't even get all those into my head right now. So they put all of this in as if covers the whole universe. So this is a problem. So, I mean, there has to be a certain seriousness in how the threat is perceived, how it is communicated to a people, how you put it into the law, and how you preserve the right to the maximum extent possible. That's the job of the state. Right. Expanding the rights of the people is the job of the state. Right. To say that there is terrorism and therefore to protect you from terrorism, I'm taking away all your rights, actually privileges the terrorists, not the people, not the rest of us. So that's one. And the other is that, surveillance is not a new thing. We've had surveillance forever. The first two cases on privacy were actually, they were not on privacy, but, which is referred to, both of them were about surveillance cases in the context of a criminal offense. And then even in that, they had to see how far can you go? Even if you suspect that a person is doing some great wrong, how far can you go? And you've had a number of cases trying to think this through. Can you say that I will put a CCTV in every room of your house so that I can watch what you're doing? There are questions that are being raised now, for instance, about whether it's all right to have an electronic anklet or a bracelet so that you can be tracked even inside your room when you go to the loo, when you're with your family, when you're eating. The level of intrusiveness that this permits is what is making everyone worried. And we have to add one more thing to that actually, the one thing that's been said for the longest time is our criminal justice system has been collapsing for the longest time. And we assume that those who are keepers of law and order, as it were, are the people who don't do wrong. But now we know that is not true. People who are actually in those positions are also human beings. They also become part of rackets of various kinds, whatever. So the shoring up of the criminal justice system is extremely important. When you look at the criminal law amendment that was made in 1922 to the Criminal Procedure Code, and then you add one whole thing saying you can collect DNA from people and keep it for a period of 75 years. Trials don't happen; they'll carry on forever. So your DNA becomes a property of the government, which then the law says can be used in multiple places. Just use it.
Right.
And use it for surveillance. So if you find it anywhere, so there already, and I'll stop with this because it's a very lengthy exercise in this. But just to say this, that, already in criminal law, we find that there is a problem of what is called confirmation bias.
Right.
When a police picks up somebody, that's what happened in the case of Surinder Kohli in that Nithari case. You pick him up, and then all the evidence that there is, you will ignore all the evidence that that would lead to his discharge. But you keep all that. You keep on trying to interpret everything so that you can pin the blame on him. This is a very common practice, and it's not just Indian. This is the way investigation happens. These are the biases that enter the system. Now, if you're going to launch surveillance of this kind and say, okay, if I find that A plus B plus C plus D, oh, this must be the person. It is what in a slightly different context, Cathy O'Neill called weapons of math destruction. You use mathematics to destroy people's lives. And it's very important that, our country hasn't produced enough literature, partly because we don't have the same free speech as people do have in other countries. And if you look at all the literature, I know Justice Krishna was saying that, Sri Krishna was saying, don't bring in the American scholars. But actually, the amount of writing that they've done and the access they have to information, which tells us about those companies and how they bring in biometric technologies, facial recognition, what they are doing with all of that. I think it is important for us to understand that, because we say very glibly, what is wrong with surveillance? Right. Do we even know what are all the things that go into surveillance? And do people who are asking that question know the extent to which they are being surveilled? Even now, even as we speak, is that the life we want to lead? Is what, one of the questions we have to ask.
No, thank you for mentioning that. And before we go to closing remarks, because we're nearing on time, and I would love to hear from, I'm going to take the advantage I have as moderator and try and steer you towards something I'd like each of you to touch upon in your closing remarks. But Dr. Ramanathan, at the end, you alluded to the position of companies and accountability. Now, to borrow momentarily Justice Sri Krishna's heuristic of the triangle, and ideally having the top axis or the top vertex being the people and the basis being trade and business and governance, it would seem, based on this discussion, that this act is enabling something more linear, with the government on top, with the trade and business in the center, and the citizen at the bottom. So amongst other aspects that you may want to comment on in your closing remarks, I was curious to know about how you see the position of us citizens vis-a-vis corporations here, particularly in light of, Dr. Ramanathan, what you mentioned, that large MNCs often look at economies and markets like India as testing grounds, the proverbial imperial boomerang of how we test our technologies here and then dispatch it elsewhere. So in addition to any other final thoughts you may have, I would love if each of you could talk about how our relations vis-a-vis the companies under this act and where you see it going. Dr. Ramanathan, if you'd like to start first. And
I think the world has changed in the past 20, 25 years, and we need to recognize that the world has changed. I know that after the Second World War, we had this carving up of the nations and territory being identified with nations. I think the idea of borders and boundaries has shifted dramatically after the advent of these new technologies. And internet was like the most exciting moment, but the excitement has become anxiety very fast, and we need to understand why. I think in the adoption of technology, see, companies are constant, and there are many films that have come now, documentaries which tell us how our mind is being infiltrated so that we cannot do without these technologies. Right. And we have to have every one of those. I think some amount of thinking for ourselves and recognizing where this is coming from is extremely important. But what is amazing in this period is the levels of addiction that have come in. It's created mental health issues. You've had whole hospitals and departments being set up to deal with the kind of addictions that are coming in. It's causing social upheavals of various kinds, political upheavals of even larger kinds. So I would just say this, that when the corporations today, we saw, I think the most blatant thing that we saw was Musk and during the Trump campaign. And then after that, saying that DHS, whatever you have, you just have to give me all that, just give me all that information. I want all the data. And then I want to be able to go to the Mars while I'm, doing Neuralink with all of you. Right. These are not innocent times. And I think we need, therefore, to take the wisdom we've got from before, but apply it to a new world that is emerging today. I don't think the experience of the older world will be enough, but I think the wisdom from that older world will be useful in looking at the world that's emerging. It's not the same world. They are different paradigms, we can't apply many of those, things that we were comfortable applying before. We need to make that shift in our thinking. I mean, if we care about any of the things, the thing is, there is it's not apocryphal. Apparently, he did say it when Musk was talking to one of the Google founders, and he said, a super intelligence should not be created. It's very dangerous for humanity. And the founder is supposed to have told Elon Musk, why are you such a speciesist? Like you have ageist and racist and whatever. What does it matter if the species changes? So what if we, if we get linked up with a machine and that's who we are, that we are not what we are today? Why is that a problem for you?
Right.
In one sense, okay, maybe we feel that we've reached the end of our time on this earth and we become something else. But I think these are, if we really believe that, I mean, if given the extent to which we can understand the world around us, I think these decisions can't be taken away from us and handed over to companies, which then decide whether we as a species deserve to exist or not. I mean, that I will say with, quite certainty.
Thank you for that, Dr. Ramanathan. Sorry, did I interrupt you? Were you about to say something else? Oh, okay. Okay. Mr. Gupta, if you'd like to add to that your final remarks and particularly to humor me how you view corporations in this mix vis-a-vis our rights and our interactions.
So, Ronak, thank you so much for the opportunity today. And I'll just briefly touch upon the role of corporations, just add some things to what Usha ji has said, what Justice Shri Krishna has said, and then I'll proceed to my final remarks. So, the first thing which we seem to omit from the ambit of our imagination sometimes is the growth of the non-statutory corporation, which is a collaboration quite often between the public sector and quite often the private sector, which is labeled as an initiative. This again breaks the regular traditional mode of how there needs to be a legal basis for the state support which is given, because the state support leads to the assimilation of technology which may be coercive. To make it more tangible, if you look at the Digiyatra Foundation, it is a private corporation which holds biometric data. At least they say they don't have authentication data, but there's no way to check it properly because it's not set up by statute. Its procurement norms are absent and the RTI does not apply. The second thing I wanted to state is that when we look at technology companies, they are driven by the ideological libertarian thinking, in which social justice is disempowered, and there is a need to create a monopoly in the sector in which they operate. It is quite common to find the phrase 0 to 1 in the technology startup sector, and it comes from Peter Thiel's book, who's a lawyer actually by training, and it states that he says in so many words that competition is for losers, which is why the companies are intended through venture capital to become monopolies, to have outside profits, which is why so you have to look at why the organism exists, the biological or the financial imperative of the organism. And for for artificial entity, it is expansion, growth, and its economic growth is its base. And finally, I'd just like to say most of the companies are also building, even if they are not primarily data companies, are building a component in the digital transformation of either using data or even selling that data. Every company which gathers data from us over a period of time becomes interested in greater amounts of surveillance, and thereby we needed a strong law. I hope through a process of years, this law improves. Now, briefly, my final comments. My final comments draw from the work of Neil Postman, who's put questions to us how we should we think about technological change. And Ronak, it goes to the questions you were putting to me. I think any conversation for me is very, very useful when I get to learn about new things I should read, but also questions I need to think about. So Neil Postman, who's written so many books about technology, was a media scholar, looked at the impact of television, put 5 questions, which I'm reading from his address at the University of Waterloo, which was given in 1998. He says that these are my 5 ideas about technological change. First, that we always pay a price for technology. This is what Justice Shri Krishna was also saying. The greater the technology, the greater the price. Second, there are always winners and losers, and the winners always try to persuade the losers that they are the real winners. Third, that there is a embedded in every great technology an epistemological, political, or social prejudice. Sometimes that bias is greatly to our advantage. Sometimes it is not. The printing press annihilated the oral tradition. Telegraphy annihilated space. Television has humiliated the word. The computer perhaps will degrade community life, and so on. Fourth, technological change is not additive, it is ecological, which means it changes everything, and that is therefore too important to be left entirely in the hands of Bill Gates. And fifth, technology tends to become mythic, that is, perceived as part of the natural order of things, and therefore tends to control more of our lives and is good for us. I could supply some additional important things about technological change, but I will stand by these for the moment and we will close tonight. Our unspoken slogan has been technology over Alice, above everything else.
Super
And we
Alice.
have been willing to shape our lives to fit the requirements of technology, not the requirements of culture, which is our life. This is a form of stupidity, essentially, in an age of vast technological change. We need to proceed with the eyes wide open so that we may use technology rather than be used by it. I would like to also put this in the link on the YouTube. On the YouTube webcast, so people may engage with the work of Neil Postman and look at how technologies and waves of them, which have been shown to be inevitable, have not been, and how they have impacted society in very different ways. For instance, political debates used to run into hours by candidates for elections have been reduced to sound bites. What does it mean?
Right.
Okay. Thank you so much, Ronak.
Yeah. Thank you so much, Mr. Gupta. And to close it off, Justice Sri Krishna, your final
No,
thoughts on the thoughts.
I personally feel, I'm sorry, I must confess, I have not studied in an American university. I have not studied the books that is written in America. My knowledge is very limited in that sense.
Right.
Now, next is, Usha was talking about, there are books produced there because it is a free country, freedom. Madam, that appellate will not be true any longer because right now there is not much of free thinking going on in that country. And let's hope that free thinking will flourish in our country at least. Although I have my own doubts on that also. Okay. Now the next third. Technology undoubtedly is a powerful tool. Never mind what the technology is. Like all power tools, it has a plus and a minus. It is our job, like any other mathematicians, to add the plus and minus and see that the result is always a positive one. If it is a negative one, you have to discard it. Whether it is medicine, electricity, or computer, internet. When internet came in, Apar was one of the first person to say internet is the great destroyer of borders. Yes, but it destroyed so many other things till today. And I'm sure he will agree with me that internet has its own inherent probabilities, inherent problems. The question is, everything has I always give this example because my wife is not there. Marriage has an internet problem, has an inherent problem. That didn't deter people from having marriages. Yeah, everything, every relation, children are internet inherent problems. But every problem has some kind of a good and some kind of a bad. Your ability to maximize the good and minimize the bad is your wisdom. If you have learned it from a book, fine. If you have learned it by experience, fine. If you have learned it from both, you are the best. That's all that I say.
Thank you so much, Justice Sri Krishna. And thank you to all our speakers for lending their time, their expertise, and their wisdom to this incredibly important discussion. On a personal note, like I mentioned before we started the webinar, as a former law student myself who looked up to each of you, read your writings, had seen your speeches, and in some cases lectures in person, it was a treat to moderate this session and interact with you personally. Thank you so much for agreeing to this. And with this, we'll wrap our 49th session of Anekdhara and would invite everyone at the end of February on the 28th, last Saturday of February, to join our next session on the details of which we will be sharing in a few weeks.